Okay, it's the top of the hour. I think we'll kick things off. Hi, everyone, and welcome to the Shoreline Property Boundaries webinar presented by the Waterfront Law Team and Gallup Surveyors and Engineers. We're thrilled you can join us for today's presentation. Before we get started, just a few housekeeping notes. If you could please make sure your cameras are on mute. During the webinar, if you have any questions, please feel free to drop those into our chat function. We have allotted time at the end of our presentation to host a Q&A. And finally, we'll be recording today's webinar. So at the conclusion of our webinar, we'll post both the recording and our PowerPoint deck on the Waterfront Property website. So with that, I'd like to introduce you to our host, Jim Lang. Jim's a shareholder and chief operating officer at the law firm of Pender and Coward. He focuses his practice on protecting Virginians who live, work, and play on the water. Jim established the Waterfront Property Law Practice Group at Pender and Coward, and he, along with the other 3 attorneys in this practice, routinely handle all aspects of riparian property laws, maritime and admiralty law, and environmental law. Clients consistently turn to the Waterfront Property Team when they need help in the court, at the local wetlands boards, and with the Virginia Marine Resources Commission. Joining Jim today will be David Butler of Gallup Surveyors and Engineers. David's a graduate of Old Dominion University. He's worked with Gallup Surveyors and Engineers for the past 32 years, serving as a partner for the last 12 years, and now as an owner. Gallup Surveyors specializes in commercial and residential site plans and surveys, as well as waterfront work preparing joint permit plans and applications. With that, it's my pleasure to turn it over to Jim and to David.
Abigail, thank you so much. And David, really good to have you here with us today. I appreciate you joining us for this webinar. We're going to talk about shoreline property boundaries. And a quick slide that gives you an outline of what we're going to cover today. The rules on how this works vary depending on whether your waterfront property is next to privately owned bottomland or to joint state-owned bottomland. We're going to talk about that. And then deed language plays a role in all of this. And then because we have David with us today, we're going to get the perspective of a on-the-ground, very experienced land surveyor who's going to engineer, thank you, and professional engineer, yeah, who's going to help us with his perspective out in the field. And then, of course, we'll have time for questions at the end. So wanted to give you a couple of quick slides to show you some of the typical problems that come up. Here you can see a piece of waterfront property, and the green line around the property is where the deed says that the property lines fall. And you can see that the property lines are shown as extending out into the Elizabeth River there at the top of this image. And so that's one of the things we're going to talk about today is what does it mean when you have a deed that says your property line extends out into a water body? Dave, how often does this come up in your practice where somebody needs help? They've got a deed and it shows property lines that extend out into a water body.
Quite often, probably 70 or 80% of everything you look at, you've got a rear property line plotted out into the water.
And then here's another, the opposite example. Now, this is kind of a busy diagram. It's a plat of property, but I want you to look up at the top of the plat, and you can see where it reads Buchanan Cove of the western branch of the Lynnhaven River. Well, right underneath the words Lynnhaven River, you look down about an inch and you see a dotted line that runs left to right across the plat. Well, that's the approximate line of mean low water. In other words, that's where the shoreline is. Now, if you look down another ½ inch under that dotted line, you'll see a solid line that runs straight, and then there's a little circle, and then it continues on at a little different angle to another little circle and so on. Well, that's the property line as shown by the deed. And so this is a situation where the opposite of the last slide, in this one, you've got a deed that shows a property line that doesn't quite reach the shoreline. We're going to talk about that today also. Dave, how often does that come up in your practice?
Not a whole lot. It's 30% maybe. It just depends on where you are, on
Mhm.
what body of water you're on, if it's a mud flat or a deep river. So
Mhm.
it just kind of depends on where you are.
Okay. And then another example of what we're going to talk about today is if you look at this aerial photo, you can see that where the land meets the water, there's a very different appearance, and that different appearance came about because the owner brought a dump truck full of all kinds of material, rocks, dirt, riprap, whatever, and dumped it at the shoreline to expand the size of his or her property. And so what are the legal consequences of changing the shoreline through man-made action, like dumping fill from a dump truck along a shoreline? Dave, do you ever run into that in your practice?
Only if the government's doing the dumping.
Mhm.
Usually, if it's wetlands, low area, because of Chesapeake Bay Act and wetlands laws, you can't fill it in.
Right, and so
So it doesn't happen often.
and a lot of this is historical. The image we're looking at here, this dumping was done in the early 1970s. It's
Okay.
hopefully that's not happening a whole bunch these days.
You don't see too much of that. If you do, it's a violation.
But whether it was done recently or done decades ago, it's changed the shoreline. And what does that do to the property line? That's the question. So we've got, we know that the shoreline is constantly changing. And I want to work through some definitions. You've got alluvium, which you can read the definition there. It's when that material is left by flowing water, and accretion is when the alluvium was put there by natural forces, and it was very gradually placed there, almost imperceptibly changed over time, not a rapid change or a man-made change. Accretion is natural forces. Erosion is the opposite of accretion. Natural forces removed the alluvium. Again, gradual, imperceptible changes over time done by nature. And avulsion is a man-made change to the shoreline, like we saw on that last slide, where somebody took a dump truck and deposited a bunch of fill to expand the size of their property. Avulsion can also be a rapid change brought on by a sudden force of nature. So, nature can either just deposit alluvium in a slow, gradual, imperceptible process over time, or nature can deposit alluvium in a sudden force of nature. Think a hurricane, for example. Dave, you were sharing with me an example of avulsion at Willoughby Spit. Could you share that with our audience?
It was probably 30 years ago. And the Army Corps was dredging material out in Chesapeake Bay, putting it on Willoughby Beach, keep the beach from eroding. And we had a series of storms, and the storms transferred that sand out to the Willoughby Point, right where you're getting on the Hampton Roads Tunnel, and you could see the land growing. And the people that lived there thought, great, I've got a bigger backyard now. The Army Corps came back and said, no, that's our sand. We're going to take that sand, and that ended up in court for a number of years.
I'd be interested to know how that court case came out.
I think the Army Corps won that one.
I wonder whether the deposition of the sand would have been considered accretion, that is slow, gradual, imperceptible changes over time, because legally that leads to one outcome. On the other hand, if that's sand showing up on those people's property that expanded their shoreline, they were happy to have it. But if it was a rapid change brought on by a sudden force of nature, or it was a man-made change to the shoreline, that would be an avulsion, and there would be a different legal outcome as far as ownership goes. So those are the kind of things we're gonna work through today. So we know that if you own property on the water, your shoreline is going to be changing constantly. The question is, when your property on the water, your side boundaries upland, they're fixed, and your boundary at the front of your property, that's fixed, but the back of your property where your shoreline is, that boundary is constantly changing. And so the question is, that back boundary, the shoreline boundary, the one that's constantly changing, as it moves around, as it shifts, does my property line follow that shifting shoreline, or does my property line stay put? And the answer to that depends on whether your property adjoins privately owned bottomland or state-owned bottomland. If your property is next to privately owned bottomland, the shoreline, when it shifts, is not going to pull your property boundary with it. But if you're next to state-owned bottom, when the shoreline moves, your property line is going to move with it. And I've given you at the bottom of this slide the Virginia Code reference for that principle. The boundary follows the mean low water mark. So if you have accretion, that is the slow gradual through natural forces deposit of alluvium on your property line, and you're next to state-owned bottom, accretion is going to expand your parcel size. And erosion, on the other hand, is going to reduce the size of your parcel. But it's going to be the who owns the bottomland next to your property that's going to be determinative of whether your property boundary moves when the shoreline shifts. And that's whether the property line, whether the bottomland is owned by the Commonwealth or it's owned privately is going to be the key factor. So let's talk about examples of privately owned bottom. Where is the privately owned bottom? Where's the bottom that's owned by the Commonwealth of Virginia? Lakes and ponds in Virginia, that bottomland is privately owned. That's a great example of privately owned bottom. Let's say you're on a creek or river. Well, we're going to break this down into two categories, tidal and non-tidal. If you are on a non-tidal creek or river, the general rule of thumb is, well, as long as it is non-navigable, then that bottom's going to be privately owned. But that's the way the courts look at it, and the U.S. Army Corps of Engineers has methodologies for determining navigability. The VMRC in its subaqueous guidelines looks to the drainage area that flows into that non-tidal creek or river, and if it's less than 5 square miles, or the flow in that non-tidal creek or river is less than 5 cubic feet per second, then that'll be privately owned bottom. So in non-tidal creeks and rivers, there's going to be a fair amount of privately owned bottom. And again, if you have waterfront property next to that non-tidal creek or river, and your shoreline moves around, your property line's probably not going to move with it if your creek or river meets the criteria I've just mentioned in that second bullet on the slide. Let's talk about tidal water bodies, a tidal creek or river, the bay, or the ocean. Chances are that bottom is going to be owned by the Commonwealth. In the vast majority of cases, the Commonwealth is going to own the bottom. And so what that means is when your shoreline changes because of erosion or accretion, your property line is going to follow that change. And so that's the difference between privately owned bottom next to your waterfront property and bottom that's owned by the Commonwealth. Give you another example of privately owned bottom. You've got a nice piece of upland property and you excavate it and it fills with water. One example would be a developer creates a stormwater pond as a best management practice. Well, the fact that the land was excavated and it filled with water didn't change the ownership of that bottomland. The private party who owned that upland before it was excavated and then flooded with water still owns the bottomland. And then in Virginia Beach, we had a developer back in the 1950s, McCluskey, I think was the man's name, who developed a neighborhood called Chesapeake Colony and had a lot of, when he subdivided, had a lot of lots that were separated from the Lynnhaven River. And so dug canals on the private property to let the water flow in and create waterfront access at the lots in Chesapeake Colony. Well, those canals would be, the bottom land in those canals would still be privately owned because it was privately owned land that was excavated and then filled with water. And Dave, I'd just be curious, you do a lot of work permitting projects on the water, piers and the like. How does approval for a pier work if your client has property on a man-made canal? Is it any different than the regulatory process to get your permits for a pier that's on state-owned bottom land?
No real difference other than the state VMRC is going to most of the time not take jurisdiction all of the time if it's man-made. You still have to go through the joint permit process. So you have to file plans and application with your local jurisdiction and the Army Corps.
Mm-hmm.
You file them with VMRC, but they're going to send you a no permit required letter. And there'll be the clearinghouse that forwards that to the other agencies.
Sounds like because it's privately owned land, the VMRC is sort of the landlord of the bottom land that's owned by the Commonwealth. And so in the situation where that canal was man-made and the bottom is privately owned, the VMRC doesn't really have that landlord hat on anymore. It doesn't need to give you permission.
No, they send you a no permit necessary letter, NPN it.
Mm-hmm.
But there's still the clearinghouse. Yeah. If you have questions or you need to meet out on site, they're very proactive. Mm-hmm. They still show up and help out with the process.
Okay. So those were examples of privately owned bottom. And on the creeks and rivers that were non-tidal, we were talking about whether it was navigable or non-navigable, because if it was non-navigable, then that bottom would be privately owned. And so the determination of navigability, if you're in waters that are tidal, it's pretty much always going to be navigable, even if it's very shallow. It's the fact that it's subject to the ebb and flow of the tide. But if you're non-tidal, that creek or river up above the fall line, the question of navigability, if you're looking at the court cases, they're going to say that it's navigable if it's capable of being used as a highway for commerce. They're looking for whether trade can be conducted using the customary modes of travel and the like. And so if it's found to be navigable, then the bottom's going to be owned by the Commonwealth. And if it's non-navigable, then it's going to be privately owned. And again, the Army Corps of Engineers has a process for determining navigability. And there's stretches of rivers where they've done that. And then you also have the guidance that came out of the VMRC subaqueous guidelines that looked to how much drained into that water, the five.
Let me see if it's working.
Okay, I understand we're having a technical difficulty. Now we're back in business. Okay. So the navigability determination you've got the VMRC subaqueous guidelines that also can come into play there. And if the creek or the river is non-navigable, then the waterfront owner is going to own the bottom out to the center line of the water course. And this rule will apply even if the deed says that your property stops at the water's edge. It's by operation of law, you're going to own out to the bottom, whether your deed says so or not. So navigability, very important in determining waterfront property owners' rights when you're on non-tidal waters up above the fall line. Lakes and ponds, obviously not tidal. And the bottom is going to be owned, but the language in the deed is going to be very important in determining your rights as a waterfront property owner. There will be some deeds that give that convey the parcel out to the edge of the water, and they don't talk about who owns the bottom land, even though that bottom is all privately owned. In the situation where the deed does not explicitly grant a specific defined parcel in the bottom of that pond, the courts, by operation of law, presume that that waterfront property owner nevertheless owns that bottom, and then has different methods for figuring out how to draw the lines on the bottom depending on the shape of the waterway and who owns how much shoreline. But the key point for the waterfront property owner in this situation is all of the waterfront property owners would have a common right to use the surface of that pond for boating and fishing. If you're on a lake or a pond, however, and your deed and the deeds of the other waterfront property owners specifically convey a definite portion of the bottom land, then each of those waterfront property owners can preclude others from boating or fishing over their particular section. It's no different than if you had upland and you want to put up a fence around your property, you can do that to keep others out. And there's even a Supreme Court case from the 1950s where a person with a deed that identified their specific parcel under a bottomland on a lake or a pond, they put up a fence on the pond to keep others from boating in their area of the pond, and the court said that's fine. Okay, I've got about 4 more slides of to share with you about how the courts and how the legal rules work on these things. If you have a deed for waterfront property, but the meets and bounds in the deed stop short of the edge of water, in other words, your deed doesn't convey to the edge of water, you're generally presumed to reach the mean low water mark. And there's more than one Supreme Court case in Virginia that says that. I've given you a citation to the one from the 1850s. And about the only time where you run into trouble if your deed doesn't convey to the edge of water, but instead has meets and bounds and creates a line that no longer matches where the shoreline falls, the only time you'll run into trouble is as a waterfront property owner is if there's some other conveyance for that little strip between your back property line and the shoreline, that very unusual situation. Most of the time you're going to be fine. And then in most cases, some cases you'll have your deeds for waterfront property will give you a property line that extends out beyond the mean low water mark. And if the Commonwealth owns the bottom next to your property, that's going to be a nullity, but it'll be perfectly valid if you're next to a lake or a pond or a non-navigable river or creek. And I know, Dave, you were telling me about detention ponds being an example of, waterfront property next to a detention pond that has a deed that projects a property line out into the detention ponds. How often do you run into that, and how does that come up? How are those things handled?
Well, when you create lots, specifically Virginia Beach and Norfolk and probably a lot of other places, when you create lots, because of stormwater management, you need to put in best management practices, wet or dry detention ponds, and you plat those out to the center line of the impoundment, the lake or whatever you're doing. And the city still maintains that pond because they realize, or the municipality maintains it, they realize the homeowners aren't going to dredge that pond out and clean it every 10 years or whenever it needs to be done. So you plat an easement around the entire pond, and then maybe another 25 feet up on high ground gives the city room to get in there and work on the lake. You own the lake, but the city maintains it. And you basically give an easement to the city or whatever municipality you're working at. It gives them the rights to go in there and clean it or maintain it. And generally, if the city doesn't want the liability, somebody gets hurt in there. That's why the homeowner owns it.
I could see why the city would keep an easement like that, because your typical homeowners association might not be equipped to do the work to maintain that stormwater pond.
Well, the city streets that are, owned by the public, are draining into that, and they're carrying trash and debris and sediment in there. And over time, that pond's filling in, and you're losing your stormwater volume and possibly creating a problem downstream by not having enough storage upstream. So the city has to go in there and maintain that, and they have to have the legal right to get in there to do that. So that's why they platted easement over it.
Gotcha. Great. Okay. We've talked a lot about mean low water, and wanted to spend a minute putting some flesh on the bones of that concept. The word mean, I put quotes around it because that's important in the statute. If you're in tidal waters, the low water mark is going to come about 2 times a day with each tide cycle, and it's not going to be in the same place. And so it wouldn't make sense to have your property line moving at each low water cycle in the tide cycle. And so instead, the legal standard is mean low water, which implies averaging. Averaging is over an epoch, a 19-year period. And so then how do you find out where the line of mean low water falls on a tidal property? And I've given you an outline of some different approaches that have been used. One from a 2-week sampling period in a court case from about 30 years ago. And then another that VIMS put out in one of their presentations about 10 years ago that involved gathering readings for 30 days at the site and putting marks on the ground or stakes and things like that and averaging them. But there's a much better way of doing that now using the vertical datum transformation program, the VDatum program that was developed by NOAA and the Army Corps. And what's involved in VDatum is to use the readings in a tide gauge to get to get an elevation where the 19-year average falls at the tide gauge, and then somehow convert that to so it's usable at the location where you're trying to establish mean low water. Dave, tell me how that's worked in your practice, establishing mean low water at a specific site reference to a tide gauge.
That's really, in my opinion, the best way to do it, because you have a 19-year average. Instead of setting up a gauge in your yard and running home from lunch to see what mean low water is, it takes a lot of time and it's not very accurate. So you can look up tide gauges on the internet, and NOAA usually maintains them. So you look for a gauge that's near where you're working, and that sheet of paper you get will say that mean low water is X amount of feet or meters from some nearby fixed point, and mean low water is X feet or meters as well below that fixed point. Okay, so that's just a number. What does that number mean? Well, we're engineers and surveyors, and people that prepared topo maps are working on either a 1929 datum or an 88 datum. Right now, we're on the 88 datum. So you don't want to mix apples and oranges. You don't want to say, well, here's low water. Well, as reference to what? You want it reference to the 88 datum currently. So we can go to the county, get a list of their benchmarks, and survey out to that NOAA benchmark and find out what the elevation is on that NOAA nail benchmark. And then we'll just take they told us it was X amount of feet or meters from that nail down to mean low water, so we can convert that to the 88 datum. So now we can draw that contour of mean low water right on the plat we're working on, or on the survey we're working on, and there's no question where mean low water is. We can also use biological benchmarks and look and see where the seagrasses stop growing as you get closer to the water, and where they transition from one variety of vegetation to a different variety of vegetation. That's another benchmark we can use.
I can see that this is very complicated. I'm glad we have professional engineers who know how to do this.
After you've done a couple of them, they're pretty easy.
Okay, so property line at a waterfront property on a non-tidal river or creek. It's going to be the center line of the water course if that non-tidal river or creek is not navigable. And then there's also, besides the test of navigability in the court cases, there's also the rule of thumb that the VMRC uses in this same situation. They're gonna agree that your property line is the center of the water course if the drainage area that feeds that river creek is smaller than 5 square miles or the flow is below 5 cubic feet per second. If you don't meet either of those criteria, then that non-tidal river or creek is navigable, in which case the Virginia Code says that the boundary is going to follow the line of mean low water. The waterfront property owner is not going to own the bed of that creek. And I would note that VMRC in its subaqueous guidelines, instead of the line of mean low water, they talk about the ordinary high water mark. And there is a difference between those two, but I'm not sure that it comes up all that often. And Dave, you were talking about using tide gauges to find the line of mean low water. Are there, how and where do you find tide gauges? If you're working in one location, are the tide gauges abundant, and then in other locations might tide gauges be few and far between? How does that work out in your practice?
Sometimes the tide gauges are non-existent. In Virginia Beach, where we have expensive waterfront property, we don't have very many tide gauges. The city's put some in recently, very recent. So the numbers we get from those, they haven't been averaged out. So they're not of a lot of use right now. You go to some counties, you go to city of Norfolk, they have plenty of tide gauges. So you don't always have it. That's where you have to go out and do your own study. You can use the biological benchmarks we talked about before, or you can just come out and survey it several weeks in a row, check mean low and mean high, and get your own average. But you can have a lunar, a full moon that's pushing the water way out or way up. So it's not very, very accurate, but it's all you have to work with.
There's all these variables that go into where the water moves, but the water moves that shoreline. And if your waterfront property is next to land that's owned by the Commonwealth, or bottom land owned by the Commonwealth, then your property line is going to be moving as a result of all these forces.
That's right.
Okay, so I showed you a slide early on where we had a property that in the 1970s, there was an individual who brought a dump truck and deposited a lot of fill along the shoreline and increased the size of his or her parcel. The word for that is avulsion. That's a man-made, very rapid change to the shoreline, not done by nature, not done over time. And where you have an avulsion, it's not going to change the property line. Erosion and accretion do change the property line if you're next to state-owned bottom, but an avulsion will not. But there's, as with every rule, there's an exception to the rule, and written into the code is a recognition that there was a lot of bottom land that was filled, early on in the 1700s, the 1800s, even through the middle of the 1900s. And if state-owned bottom land was filled prior to July 1, 1960, then that island or that extra land that was created through that fill activity is going to be privately owned, even though it was done over bottom land owned by the Commonwealth. The Commonwealth's going to agree that that's eligible to be privately owned. And then there's always the possibility that just through the forces of nature, on the bed of state-owned bottomland uprises an island. And by code, that island would be owned by the Commonwealth. It would not be privately owned. And here's an example of a man-made island in the Potomac River. It's called Holiday Island. And you'll see there's more than one of these in the Potomac River, and they're very popular with duck hunters. And this particular island, our research indicates that it was created in the 1920s by a company called Smoot Gravel. And they took a barge, it was filled with gravel from some location, and they sank the barge. And that created the foundation on which they continued to add material through the years until this island had been created in the middle of the Potomac River and now is privately owned. It's an example of an avulsion. It's done on state-owned bottom, but since it was created prior to that date in 1960 that's mentioned in the code, it's a privately owned piece of property that was created on state-owned bottom in the Potomac River. So I thought we would return now to the three examples I gave you at the front of the presentation. We should be able to come to a fairly quick answer as to the questions that are raised by the image. Here we have a piece of property outlined in green lines with the property boundary, and the deed extends those property boundaries out into the Elizabeth River. But since the Elizabeth River has bottom land that's owned by the Commonwealth of Virginia, we know that the property owner's waterfront boundary is at the line of mean low water. And so the deed that says there's a property boundary out into the water, well, that's just meaningless. That property owner does not own the bottom land out into the Elizabeth River, even though the deed says that he or she does. And then let's come back to the other side of that coin. This is the situation where you have that dotted line just below the word Lynnhaven River up at the top of the image. And that dotted line is showing you the approximate location of the shoreline, the approximate location of mean low water. And the deed gives boundaries that stop short of that shoreline. And so the question is that property owner own out to the shoreline, or does that riparian waterfront property owner's property stop short of the shoreline? And I gave you the court cases, or gave you one of the Virginia Supreme Court cases from the 1850s, and it's one of many that says, well, if this is a situation where the shoreline moved away from the boundaries that were placed in a deed, the deed having been created at one point in time, and the shoreline moved away from the boundary created in that deed, by operation of law, that waterfront property owner is going to own out to the line of mean low water. And also gave you the example up front about the avulsion, the dump truck dumping material along the shoreline to expand the size of the property. And we now know, because of the legal rules around avulsions, unless this was done before 1960, the deposit of all this material to expand the size of this person's property is not going to move the property line. They were filling on state-owned bottom. This was on the Elizabeth River as well, so it was state-owned bottom. And the state is still going to own that bottom that's now been covered by the material deposited by that dump truck, unless the deposit was done prior to 1960, or if it was done after 1960, if it was done subject to valid permits. And to get your permit to do fill like this, you're going to pay a royalty to the VMRC to compensate for the change in ownership of that bottom land. But if none of those steps were followed, and this was dumping in the middle of the night, the state's still going to own that bottom land, and that fill would be expose the person who did it to enforcement action by various government authorities. Well, I want to thank everybody for joining today. We've recorded this webinar, and we will be posting it to my website, www.waterfrontpropertylaw.com.